What if I told you that most of the time, original bank or lenders won't sue you over a debt? And when they don't, that's your opportunity to fight back and win. In this video, I'm going to be breaking down why original creditors usually disappear after a charge-off, how debt buyers take over, and what it really means when the party is suing you isn't the one you borrowed from. I've studied debt law, the UCC, the consumer rights, and I'm here to help you understand how to use this information to your legal advantage. So before we dive in, thank you guys for watching this video. If you're brand new, make sure to like the video, make sure to subscribe to the channel because I drop daily bangers. All right. Now, also in the same time, this is not legal advice. Do your due diligence. Okay. You can listen to everything that I'm saying and think that you can be able to regurgitate this or have the confidence after watching this. Then yes, you'll have some confidence, but I always tell people to do their due diligence, cross-reference anything that I'm talking about right now, and make sure that you fully understand what you are getting into before you even dive into this, okay? All my rights are reserved, so this is only for educational purposes only. But the main focus is understanding that banks will take advantage of the fact of, we talked about double dipping, right? We talked about how they sell your loan and how they securitize it. We talked about many different aspects of the loan that further proves that the debt is already sold, settled, there's no money to be loaned, this, that, and the third. And then at the end of the day, after all of this is true, they then sell your debt, okay? And the person that typically tries to sue you are the collection agencies, okay? And so essentially when I talk about this, I want to bring up a couple of red flags that you should be able to tap into, or how you know that you're dealing with a debt buyer, okay? So usually, if the company you originally borrowed from isn't the one suing you, that should tell you something, okay? If it's a collection agency, if it's some Metro Systems, if it's a third-party collection agency, if it's a law office, so on and so forth, typically they are not the original creditor. And I'm putting this here because creditor is, you know, there's many definitions for creditor, but in this case, the company that created the credit, such as a Chase, such as an American Express, such as a Discover. Usually what they do is when you decide to default on a loan, or when you decide to stop paying, or when you are not paying it, then they charge it off. Most of you guys don't know what a charge off is. A 1099-C was filed, and when it got charged off, that debt was actually settled. Okay, that became taxable income to them. Okay, so not only that, but the debt is insured as well. So it's already a guarantee that if you don't pay your debt, that is already guaranteed. And then we could talk about the fact that there's a promissory note that you actually signed that gave them the ability to create credit, actually funded the loan. But we're not going to talk about that right now. Let's just say there's a debt to be owed. They sold your debt, okay? And when they sell your debt, they write it off and claim the loss on their taxes and move on. That's through the 1099 process. But typically what happens is after all of that happens, you instead get sued by companies like Portfolio Recovery, Midland Credit Management, LVNV Funding. But typically what happens is they just bought your info and not really the contract. So they didn't lend you money. They just bought a claim, not a contract. And a lot of you guys don't know that this is another game. Okay? This is another financial game. Buying debt and then coming after the person who essentially owes a debt, almost like a loan shark. Okay? So they take on the responsibility of collecting the debt, but there's nothing you particularly owe them. You didn't tell them to buy a debt or your debt. You didn't tell them to do that. Nor was you even notified that American Express, Discover, Chase even sold your debt. See, there's a thing under the Truth in Lending Act that they must provide a full proof of full transparency and full disclosure, anything and everything that has been done with their credit. So if they wrote off your debt, they need to let you know. If they sold your debt, they need to let you know. Okay? So here's why the original creditor won't sue you. Number one, they already made their money, whether it was through charge-offs, whether it was through tax deductions, whether it was through insurance payouts, possibly even 1099-C cancellations, okay? And sometimes through securitization or bundling into asset-backed securities. This is what I talked about in my previous video under They Sold Your Loan. I'll go ahead and link that right above, okay? Now, when this happens, they really have no financial interest left in going to court, so they just dump the account. They sell it off to a debt collector. Just think about it. Why would they go through all the rigmarole if they made money off of it multiple times? Why would they go through all this rigmarole just to pay their lawyers to sue you? You know? And some people will say, well, oh, okay, well, maybe they're just trying to get the money that they loaned you. Well, they never loaned you money in the first place, and you can easily challenge their consideration to that. But they, like I just said, they made money off of your account multiple times. So yeah, if it's easy money, yes, they'll do it. But this is why they don't. And I'm going to talk about how to be able to fight back against that, because, you know, they don't want to go the distance with somebody. They don't want to spend all this money on lawyers and things of that nature, especially if they already are, if they already made their money. So I'm just speaking in circles at this point. So this is what happens when debt buyers take over. Debt buyers purchase old accounts for pennies on the dollar. Okay, so what happens is they get basic info, name, balance, maybe even payment dates, but usually not the original contract, the ledger, or proof of chain custody. Okay, proof of the chain of custody. Okay. And typically they rely on intimidation. Okay, they want to scare you into paying. They want to scare you into an agreement by not, notifying you of your rights, or you just not knowing your rights in the first place. Okay, it's not really their ability. It's not really their job to tell us our rights. It's their job to just expect us to know our rights. Okay, but they know you don't. Okay, they know you don't look at the FDCPA 15 U.S.C. 1692G that essentially breaks down the validation of debt. They know you don't understand the aspect of what is a form of harassment under the Fair Debt Collection Practices Act. They know you don't understand what the holder in due course is. They know you don't understand, the UCC and things in that nature, consumer law, your protection as a consumer. And this is why they go ahead and do this, to even challenge that. Okay, because if someone knows the law and they're able to fight back, then more than likely they're going to take a back seat. Okay, so they really sue hoping that you default, not because they have solid proof. So typically what happens, they send a letter attempting to collect on a debt, maybe even make multiple phone calls before they actually send a letter. Okay, they'll make multiple phone calls, try to get you to pay over the phone, and then depending on how many times they call, they may send a letter of debt collection. They'll say, this is from a debt collector, so on and so forth. You owe X amount of dollars. Usually we ignore it. Usually we get that letter and we say, oh man, I'm just not even going to say nothing. But that's exactly what they want. They want you to not respond. They want you to ignore the letter. So, we'll talk about what the legal framework and how to do these things, but they want you to ignore the letter. Then they send a second letter saying that hey, this is our second attempt of reaching out to you. This is like their notice of dishonor. This is our second attempt reaching out to you. If you don't respond, or if you don't pay, then we are going to sue you. So then we dive into maybe a third letter they'll send out. And sometimes they don't do all of this back to back. Sometimes they try to make phone calls and keep sending letters and things of that nature. But if they send enough letters over time, they'll eventually send that intent to sue. And that intent to sue is another form to get you to agree to pay them. And a lot of times when you don't respond, you acquiesce to whatever it is that they say that you owe them. So it's important for you to respond back to these companies according to the FDCPA, and we're about to talk about that right now. Okay, so here's the legal framework. Okay, first things first, we're going to talk about 15 U.S.C. 1692G. One of my favorite laws to talk about is 15 U.S.C. 1692G, or the FDCPA in its totality, because this is the very section that gives you the right to challenge the validity of a debt, okay? And this is the validation of debt. Within 5 days after the initial communication of a consumer in connection with the collection of any debt, a debt collector shall, unless the following information is contained in the initial communication or the consumer has paid the debt, send the consumer a written notice containing the amount of the debt, the name of the creditor whom the debt is owed, a statement unless the consumer within 30 days after receipt of notice disputes the validity of the debt or any portion thereof, a statement that the consumer notifies the debt collector in writing within 30-day period that the debt or any portion thereof is disputed, so on and so forth, okay? It talks about the process of disputed debt, but here's one of the things I want to highlight. The debt will be assumed to be valid by the debt collector if you don't send them a statement, if within 30 days you don't dispute the debt, okay? So it's important for you to dispute the debt within those 30 days. And it says it here under the 15 U.S.C. 1692G that you have a right to do that. Okay. So part of this, okay, the failure of a consumer to dispute the validity of a debt under the section may not be construed by any court as admission of liability by the consumer. Okay. But if you wanted to understand the aspect of your right under the Fair Debt Collection Practices Act to validate debt is written right here. Okay. We can even dive into the different harassment practices that they do to try to intimidate you and scare you, such as unfair practices, such as false and misleading representations, such as harassment or abuse, calling you multiple times, trying to reach out to you, sending you multiple emails, calling you at weird times of the day, communication in connection with the debt, improperly communicating their debt collection. Acquisition of location information, meaning they got your information without your consent. Civil liability, what their liability is for any of these violations under this subchapter, okay? And furnishing deceptive forms, making you think that this form is something that it is not, So under the Fair Debt Collection Practices Act, you have a right to demand debt validation, and most debt buyers cannot produce the original documents once you start to validate that debt. Okay, we're going to talk about the certain things that you want to ask for, but let's just go ahead and keep moving forward and talk about the person entitled to enforce. Now, I talked about this in my last video, but this also goes hand in hand when it comes to people that buy your debt, and it's very easy to use this against them because according to this, they have to be a person entitled to enforce. And what that means is that they legally own the debt. If they are the person entitled to enforce the instrument, then they legally own the debt. If they cannot prove that they legally own the debt, then they cannot sue you, okay? But you have to ask them of these things. You have to get them to prove these things. You have to challenge them on these things, okay? If you don't challenge them on these things and you don't have no record or no paper trail of you challenging them on these things, you go to court trying to fight the debt collector and you try to throw this out at them. If you did not ask them of these things over the period of time of them attempting to collect on a debt, then you will not win in court, okay? But you can appeal, okay? Then we dive into UCC 3-305, which talks about defenses and claims and recoupment. This is specifically you being able to challenge the claim based on lack of standing, fraud, or no consideration. Now, what is no consideration? They didn't exchange anything of value to you. They just bought the debt, and now they're trying to come after you. See, that's not your fault that they bought the debt. If you didn't get no real contract with them, then you have no liability to them, okay? The contract is formed when they send a debt collection letter to you, and you have to perform on it in some type of way, whether you're going to agree to pay, or whether you're going to send them a letter back of debt validation, or whether you're going to send them a letter and say, well, what is this? You got to respond. You have a ability. You have to respond to a presentment. Okay. You cannot leave a presentment responded to. Okay. And then we dive into 15 U.S.C. 1681, which typically talks about the fair credit reporting. And usually when it comes to debt collection, okay, charge-offs and things of that nature, it's not the fact that somebody is attempting to collect on your debt that really makes us feel away, because they can send us letters all day, but if we just ignore them, then technically it's just paper coming in our mailbox. It isn't really a problem until they sue you, okay, or attempt to sue you. But if you send a debt validation letter and things of that nature, then they will never just sue you. And this is just, I'm just saying this, not saying that it's always going to go like that. But if you are sending constant communication, this will keep them from suing you, at least being confident in suing you. Okay, you always want to respond back to a debt collector, but the one thing that they will do to get you to try to pay is put that negative mark on your credit report. So on your letter, you want to notate the Fair Credit Reporting Act and tell them to remove any unverified information off your credit report. You want to put that in your debt validation letter, but also at the same time, if these collections show up on your credit report, instead of paying them, just send a letter to the credit bureaus with the information of you attempting to dispute the debt and them not responding or them providing the proper disclosures. And the credit bureaus must take these things off. Okay? If they don't do that, then they're not doing their job. Okay? And that is actually a violation of your rights. So they cannot report false or unverified debt, and you have the ability to dispute and sue them for reporting false and unverified debt. Okay? So if you pull up to court after challenging the company on 15 U.S.C. 6092G, challenging whether they are a person entitled to enforce, challenging whether they have a lack of standing, or if this was a fraudulent debt, or if there was no consideration. If you challenge them on these things and are unable to provide these disclosures, then the debt is considered unverified. So if it's unverified, take it off my credit report. That's the only thing that truly makes us feel away, is when our credit takes a hit. But understanding that this stuff can be taken off your credit report with the right strategy, you should be good. Okay? So here's how to fight back when it comes to a debt validation letter, and just making sure that you do things properly. Okay? When you get a letter from that debt collector, the first thing you want to do is you want to go ahead and send a debt validation letter immediately. Okay? You usually have 30 days to send it, but the earlier you do it, the better. Okay? A part of that debt validation letter, you want to ask for proof of ownership. You want to ask for the original contract and the full accounting of the account. Okay? Because when you do this, this forces them to essentially prove that they have a lack of standing, prove that there is that they have ownership over it. They have to prove that they are the original lender and things in that nature, or that they have that chain of assignment, chain of custody. Okay? If they cannot prove this or show any documentary evidence that proves this, then now you got to show me this. There's no conversation to be had until you can show me this proof. I'm not saying that I won't pay a debt, but prove that the debt is actually owned by you. Okay? But then also at the same time, let's say that they do prove it. Okay? This is something that you can also challenge the validity of the contract. Okay, bet. Well, if you guys did it, can you prove that it wasn't securitized or it wasn't already paid for, that the debt wasn't already settled, and you didn't just buy a settled debt? You know what I mean? So you ask them these things, and this not only will delay them from suing you, but this will put you in a space of offense instead of defense. Step 3, if you are sued, okay, one of the things that you can do is you can challenge you can keep your evidence. Okay? There's a couple ways you can do this. Okay? You can either do this on your own. You can file your own. You can keep your evidence, and you can essentially bring your evidence to court of you asking them of these things and them not providing it. Or, and this is if you don't want to do it yourself. Trying to show you guys the website to SoloSuit, but I'm assuming my internet, I need to restart my computer to basically get my internet to come back up. But besides that, the link will be in the description. SoloSuit, actually, their program, or as a matter of fact, I'll just cue the ad. Today's sponsor for today's video is SoloSuit. If you're dealing with debt collectors, right? If you're feeling overwhelmed by lawsuits, well, guess what? You are not alone. Many people struggle with this process, but here's the good news. You have rights. Of course, this is what I talk about, and you don't have to fight alone. That's where SoloSuit comes in. SoloSuit is a game changer for anyone facing a debt collection lawsuit, and instead of stressing over complicated legal paperwork or risking a default judgment, SoloSuit is going to help you respond in minutes. Here's how it works. Step 1, they're going to answer a few questions about your case. Step 2, SoloSuit is going to generate a legally sound response to your case and to your lawsuit. And in step 3, they'll even file it for you in court so you don't have to. Why is this important? Most people lose debt lawsuits by default simply because they don't respond. But when you file a response, you increase your chances of winning or getting your case dismissed. Think about it. Would you rather fight back and let them take your money without a fight? Probably not. So if you've been served with a debt lawsuit, don't wait. Take action now. Go to SoloSuit.com and take control of your financial future. Protect your rights, fight back, and don't let debt collectors win. Now that you guys have seen that and you've seen how SoloSuit operates, they'll pretty much do the work for you, okay? Now, step 4, use court discovery to force them to admit that they have no contract and no legal right to enforce, okay? A lot of times, what happens is when you challenge these companies, it really puts them in a position where they have to provide proof or else they cannot do anything like sue. And essentially, the court, when they take a look at this information versus their information, now they kind of can't just sit there and lie in court, right? Oh, well, this person asked for this stuff. Why didn't you provide it to them? Checkmate. It's literally checkmate when I do my part and you're not doing your part. That is unacceptable in the court of law. Now, I get in most times where they try to side on the side of banks, but when there's somebody that knows their rights, they cannot just take advantage of them, including the courts. They only take advantage of people who don't know it. All right. So another thing you can do is you can check your IRS transcripts to see if a 1099-C was issued. If it was, they already canceled the debt and are trying to collect it again, which is illegal double recovery. This is not seen as good in the eyes of the legal system, okay? If they try to do this and you find out, then you can use this against them. Debt buyers are not counting on you to know this, okay? But the law is very clear, all right? If they cannot prove ownership, if the debt isn't valid, don't let them scare you into paying something that they cannot prove. That's the beauty. When you shift the burden of proof onto them, now they have to provide answers, okay? Before you even pay a dime, okay? Before you even pay a dime, make sure you ask them these questions. Make sure you challenge the debt. Make sure you challenge whether the debt is valid or not. Make sure you challenge whether that contract has some real consideration, okay? If they never loaned you money, then we shouldn't be sitting here having a conversation. I don't give a dang if you bought my debt. I never told you to do that, okay? Especially if the company already made money and it was insured and it was already settled. What are you doing? I get that you guys, this is a business and you guys make money off the debt collection business, but hey, I'm not about to be a part of it. I'm going to tell you my rights. I'm going to write back to you. And when I write back to you, you already know it's nothing you can do. It's nothing you can prove. And if they're not providing a full, if they're not providing that original contract with your wet ink signature, if they're not providing that chain of custody, if they're not providing that chain of assignment, if they're not providing the disclosures that need to be provided according to the contract, according to the Truth in Lending Act, according to the Fair Debt Collection Practices Act, according to the holder in due course rule, you cannot do anything, really. And this is why I love this, okay? So obviously, I can talk about all this stuff, but one of the biggest things that you have to be able to understand is to be able to exercise the administrative process. We can break down all the things that we ask, but when you tap in and understand the step-by-step process and the things that you're supposed to take them through as soon as you get a debt validation letter, that is the most important key. The knowledge behind how to do this and knowing your rights as a consumer. So I put together the Complete Debt Guide. The Complete Debt Guide is only $47, okay? Anybody who taps into the Complete Debt Guide will be able to resell it as an affiliate and get 25% of the profits. Because in the Complete Debt Guide, and this is where the value comes, is the fact that you're going to be able to download that debt buyer challenge letter, any debt validation letters that are attached to it. You're going to be able to have your own legal response so that you'll be able to understand how to do it. And this is if you want to do it on your own, okay? Most people are putting it out there and they're making you work for it, okay? They don't give you all the things that I will give to you in this complete debt guide for only 47 bucks, okay? Number two, if you want to work with me one-on-one as it regards to credit repair, let's say you're doing the debt validation process and you still have dings on your credit report, tap into my one-on-one mentorship. We have a whole program geared towards helping you repair your credit. Number two, if you're looking to get funding, tap into my mentorship, okay? Number three, if you are looking to grow and scale your online business, tap into our mentorship, all right? Now, this is more of a private coaching experience, so not everybody is accepted. I do get a lot of people that apply and get on the phone and they want to talk about debt discharge, and I will respectfully tell them to watch my YouTube videos, okay? Because everything that I'll tell you on the phone is already either broken down in my YouTube videos, or when we're talking about the letters and things of that nature, how letters should be written, it's in a complete debt guide. So I wouldn't want to waste our time being on the phone doing this stuff, okay? And I won't be on the phone selling you a $47 package. Trust and believe. Whatever we're going to get on the phone with is going to be something that requires an investment, okay? So I'm only applying for that one-on-one mentorship if you are ready to invest in yourself, whether in regards to fixing your credit, getting funded, or getting that one-on-one private mentorship so that you can grow and scale your business. Number three, if you want to be able to do this and you don't have time to learn, tap in with SoloSuit. SoloSuit link will be in the description. We just went over it today. Tap in with SoloSuit. SoloSuit will pretty much do the hard work for you. They'll write the letters. Anywhere you're at in the process, they'll do the work for you, okay? And then lastly, if you want to follow me on Instagram so that you can be more tapped in, see me on a consistent basis, whether you want to see more legal strategy, be updated on these YouTube videos, tap in at biz.nick, okay? My last question is, ever been sued by someone you never borrowed money from? Drop your experience down below. I know you have, okay? Make sure to like, subscribe, turn on the post notifications. We are flipping the script on the debt collectors and the debt industry one bit at a time. So if you made it all the way to the end, make sure to comment the word discharge, and I'll see you in the next one.